Okay, pretty sure I'm live this time. Let's see. Let's see if I'm live. Oh, I am live. Hello, Vance. I am going to be studying for the bar, and I'm gonna do. Well, I don't really know what I'm doing yet. I haven't even looked at the bar prep service, but I should have started on Monday. But I will be studying different areas of the law. I'm no teacher, and I'm not supposed to teach anyone the law, but we are going to learn together if you would like. So basically, I'll be talking to myself. Um, Not today, but in the future, I will probably share my screen and I'll have multiple choice questions and stuff, or outlines that go over uh, just areas of the law, such as evidence, property, civil procedure, contracts. Um, I think there's stuff about wills and trusts, secure transactions, like corporations and business entities. So we're going to be doing that. Let's see. Got to bring up my email too. And if you have any questions about anything I'm studying, um, to clarify or anything, we need royalty free. I can't study with music. People are just going to have to hear me talk to myself or put it on to where I can't hear it. Okay. Register for my. No, I don't want to do that. Enrollment. I am enrolled. Hello, congratulations. You are now enrolled in Barbary Bar Review Guided Pass. Your username. Sign into my Barbary. Okay. We're going to do that. Hope this works because it's giving me a username and password already. And so, let's see if that works since I had it saved. Okay. Current start date. Study days. What should my study days be? Customize. We're not going to study on my work days, maybe? Monday, Tuesday, Wednesday. I should study one of them. So let's do Thursday. So I'm going to study Thursdays, Fridays, Saturdays, and Sundays. I work Monday through Thursday. Save. Done. Okay. 30 minutes. Videos. I'm not watching videos. Subject. So subjects are civil procedure, constitutional law, contracts and sales, criminal law and procedure, evidence, mixed subjects, property, and torts. Let's see criminal law and procedure. Messages. I'm frozen. We are studying, people. We are studying. Bob's, please. My husband's funny. Okay. Information about your digital bookshelf. Let's read that. Let's Okay. Top row, your digital bookshelf contains copies of all your Barbary books, plus 2 bonus reference items assigned in your PSP that are available for you. Okay. Instructions for your PSP has a default start date, but you can customize the schedule to fit your needs from the home screen. Then edit schedule. Please notify the changes you can edit. So I'm not taking the bar till February, but I'm starting my bar prep now. And it's probably going to be boring, but I'm going to be boring with you guys, so that's going to be fun. Getting started with my PSP. Welcome to the summer 2023 Barbary Bar Review course. We are excited to be a part of your bar prep journey. Here are a few tips to get you started with your personal study plan. Your personal study plan, or PSP if you will, has a default start date of May 17th. What's today's date? I don't think it's the 17th. Oh, it is. Look, I started on the correct day. However, with the calendar customization, you have the opportunity to select a start date that is convenient for you. Calendar customization also gives you the ability to choose the days of the weeks that you would like to regularly study. You can personalize it. Assignments to be. I have assignments. What the fuck? For my assignments, we suggest that you follow your personal recommendations. Assignments will be completed in one of your Barbary volumes, will be preceded by a 2 to 5 letter acronym directing you to the correct volume. I don't want to be in law school anymore. Remember, sign up for the Ready to Get Started webinar tomorrow. Oh, that was like 2 weeks ago. Ready to Get Started webinar replay link. Okay. MCQ Bank. Let's see what that is. Okay, criminal law procedure. Well, how do I do it? Why does my name say Ashley Unson? That's weird. Questions? Okay, let's do criminal law procedure. No, you know what? Let's do evidence. Start. We're going to do some evidence questions. Yay, stop sending me stars. You're just sending me my money back to me. The defendant is on trial for embezzlement. He does not take the stand. Assuming all notice requirements have been met, which of the defendant's previous convictions is most likely to be admitted into evidence against him? A 7-year-old conviction for arson, a felony, possibly. A 12-year-old conviction for embezzlement in a felony. Embezzlement, does that have to do with flying? I'm a veggie, sorry people. So, 2-year-old conviction for felonious sexual assault. Felonious sexual assault. Felonious sexual. 7-year-old conviction. A 6-month-old conviction for disorderly conduct, a misdemeanor. So that one's no. We're going to mark that out. Disorderly conduct's a no. The 12-year-old conviction for embezzlement is a no because usually they're not allowed to bring in, this is what I think, and I'm pretty sure this is what the federal rules of evidence say, that if a conviction is over 10 years old or 10 years from release, whichever is longer, they can't use that felony against you. However, sometimes they can, but then that has to weigh against a 403 issue if the probative value is more prejudicial than probative. So then a 7-year-old conviction for arson, a felony. A 7-year-old conviction for arson, a felony. I think that's going to be it. A 2-year-old conviction for felonious sexual assault. The defendant is on trial for embezzlement. He does not take the stand. He does not take the stand. Okay. Because he does not take the stand, the 7-year-old conviction for felony arson cannot be used against him. However, the 2-year-old conviction for felonious sexual assault, I believe, can be used against him because I don't remember the federal rule of evidence, but anything that has to do with like sexual assault or sexual acts, those, I believe, can be brought in at any time. So we're going to go with D. Did I get it right? I got it wrong. Why can that be brought in? B is correct. We're learning. The defendant's conviction for embezzlement is most likely to be admitted because the defendant did not take the stand. The evidence is not being offered for impeachment, and thus the 10-year-old limit does not apply. Is it cold here? No, it's not cold. I just have to wear things that cover me when I go to work. Evidence of other crimes is admissible against an accused in a criminal case criminal case if it is relevant to some issue other than the defendant's character or disposition to commit the crime charged. Whereas here the crime charged is embezzlement, evidence that the defendant committed embezzlement before might be admissible to establish fraudulent intent. Well, I apparently failed my evidence final. No, I don't know. If the defense objects to the board member's proposed testimony, how should the court rule? If the defense objects to the board member's proposed testimony, how should the court rule? A 60-year-old employee who was fired by a corporation after 25 years of employment filed an age discrimination suit against the corporation. While the corporation's excuse was that the reorganization and merger required a trimming of personnel, at trial the employee seeks to have a board member testify that the chairman of the board had convinced the board to fire the employee because he didn't fit our corporate image of youthful vigor. It was typical practice that all directors' meetings be recorded and that the corporate secretary use the recording to type up a formal transcript of the proceedings. The meeting at which the employee's dismissal was discussed was no exception. If the defense objects to the board member's proposed testimony, the testimony is admissible because it is based. So who's testifying? The board members' proposed testimony. The testimony is admissible because it's based on the board members' first-hand knowledge, I believe. I'm going with that one. So the answers are A, the testimony is admissible because it's based on the board members' first-hand knowledge. The testimony is inadmissible. The defense objects to the board members' proposed. Okay, A, the testimony is admissible because it is based on the board members' first-hand knowledge. B, the testimony is inadmissible because it is hearsay, not within any recognized exception to the hearsay rule. Do I have nice feet? I think I do. Yeah, I think I do. They're painted. They match my fingernails. They're like a nude color right now. So my feet match that. Anyway, moving on. I think it's A. The answer is A. Let's see. Got it right. Okay, but we're going to read the explanation because the board member's testimony should be admissible because it is relevant non-hearsay based on first-hand knowledge. The testimony is relevant. May you see my feet? No, because whereas I have nice feet, I'm not flexible and I can't get my feet up here and I don't want to move my computer. So you may not see my feet. How did me studying for the bar turn into someone wanting to see my feet? I don't get it. Okay, the board member's testimony should be admissible because it is relevant, non-hearsay, based on first-hand knowledge. The testimony is relevant to the employee's age discrimination suit because it is being offered to prove that the board's motivation in firing the employee was his age. It is not hearsay, even though the board member is repeating the statement of an out-of-court declarant, the chairman of the board, because it is not being offered to prove the truth of what the chairman was asserting. Man, that hearsay confuses the fuck out of me. Like, hearsay is a person in the now trial testifying as to a declarant's out-of-court statement not in the current trial. So, like, you can even have hearsay saying something you said. If you're like, I said blah, blah, blah this time, that's hearsay. If you said so-and-so said this, that's double hearsay. Hearsay within hearsay. And hearsay within hearsay confuses me, and hearsay confuses me. Because I'm like, just let me say what happened, and then we can figure out if that's what happened. Okay. So I got that right. How should the judge rule on the photo? A homeowner is suing a bicyclist, alleging that the bicyclist damaged her flower garden by riding his bicycle across her yard. The homeowner seeks to introduce in evidence a photo of her garden to show the damage done by the bicyclist. The photo was taken by an insurance claim adjuster who was not called as a witness. 3 days after the alleged incident, the bicyclist objects to admission of the photo. How should the judge rule on the photo? Admissible because the homeowner can testify that it fairly and accurately portrays the condition of the garden after the damage was done. Admissible because the photo was taken within a week of the alleged occurrence. No, that doesn't. Inadmissible because the homeowner failed to call the photographer. No. Inadmissible because it is possible to describe the damage. No, I think it's A. Admissible because the homeowner can testify that it fairly and accurately portrays the condition of the garden after the damage was done. I got it right. The judge should rule that the photo is admissible. Photographs are admissible only if identified by a witness as a portrayal of a certain fact relevant to the issue and verified by the witness as a correct representation of those facts. The witness who identifies the photograph need only be familiar with the scene or object that is depicted. It is not necessary to call the photographer to authenticate the photograph. The homeowner is familiar with the garden that is depicted, thus she may testify to the photo as an accurate portrayal of the condition of the garden after the damage was done. Wave it, wave it, wave it. Next question. Is the wife competent as a witness? A homeowner was helping his neighbor clean out her garage. As the homeowner and the neighbor were moving some boards out of the garage, the neighbor ran into the overhead door hinge, causing it to fall and hit the homeowner on his head, killing him. The homeowner's wife sued the neighbor for wrongful death of her husband, seeking damages of $100,000. Okay, if you kill my husband, I'm suing you for way more than $100,000. The wife, who was present when the accident occurred, is called to testify that at the time of the accident, the homeowner is the homeowner. Okay. Okay, hold on. A homeowner was helping his neighbor clean out. A homeowner was helping his neighbor clean out the garage. As the homeowner and the neighbor were moving some boards out of the garage, the neighbor ran into the overhead door hinge, causing it to fall and hit the homeowner on his head, killing him. This is a weird question because a homeowner was helping his neighbor clean out her garage. So it would be like a neighbor was helping a homeowner. It's worded weird. A homeowner on his head, killing him. The homeowner's wife sued the neighbor whose home they were in for the wrongful death of her husband, seeking damages of $100,000. The wife was present when the accident occurred. She is called to testify that at the time of the accident, the homeowner was carrying the boards on his shoulder, and he therefore was unable to see that the neighbor had hit the door hinges. Said she was there. The wife, who was present, yes. Is the wife competent as a witness? Yes. If she is testifying, yes. In spite of the fact she is a plaintiff. I have a wedgie. What, do I keep freezing, or I was just, okay. So, I gotta work this out because I don't know. So, she's testifying that at the time of the accident, the homeowner was carrying the boards on his shoulder. She saw that, and therefore was unable to see that the neighbor had hit the door hinges. How the fuck would she know that? So, it's not. So, A, yes, if she is testifying as the personal. I don't think so. No, she is unqualified to give opinion evidence. No, because she can't testify for her husband. I don't know this one. I'm going with C because that's the C, no, because she's unqualified to give opinion evidence, but that's not true because you can give an opinion, but she's not giving an opinion. Let's see. I don't fucking know. Therefore was unable to see Okay, I'm going to go with yes if she's testifying as the personal representative of her husband's estate, and I'm going to close my eyes and click answer. I got it wrong. Yes, in spite of the fact she is a plaintiff. B is correct. The wife is competent to testify. Persons interested in a lawsuit are not disqualified as a witness. I know. A is wrong because the wife need not be the personal representative of her husband's okay. C is incorrect because she is testifying as to what she saw, not as her opinion. D is wrong because the common law spousal incapacity has been abolished. I just think that was a weird question. That's the dumbs. Okay. Should the court allow the physician to testify about the plaintiff's statement? So, I don't know if I can share this. I don't know. Anyway, plaintiff applied for a life insurance policy. Plaintiff applied for a life insurance policy and was required to submit to a physical examination to qualify for the policy. During the course of the examination, the plaintiff told the physician, who was approved by the life insurance company and had never seen the plaintiff before, I used to have some back trouble, but that's all cleared up now. A few weeks after the examination, the defendant's automobile struck the rear end of a car in which the plaintiff was riding as passenger. The plaintiff now claims that he suffers persistent lower back pain and sues the defendant for damages. After laying a proper foundation that the plaintiff is attempting to perpetrate a fraud, the defendant calls the physician as a witness and seeks to have her testify as to the plaintiff's statement to her. The plaintiff's attorney objects on the grounds of jurisdiction's physician-patient. After laying proper foundation that the plaintiff is attempting to perpetrate a fraud, the defendant No. Should the court allow the physician to testify about the plaintiff's attorney? No, because the statement was made prior to the accident. No, because the statement was made to a physician in a professional. Yes. I don't know. Okay. How does the physician-patient privilege apply? Is it just if you are, yes, because the plaintiff was not seeking diagnosis or treatment? I feel like they still shared information. It's stupid. B is correct. The defense seeks to exclude the testimony by the dog handler describing the dog's reaction to the suitcase. How should the court proceed? An airline passenger was on trial for attempting to smuggle illegal drugs into the country. Of course he was. The prosecution is seeking to present evidence that when the passenger had passed the entry area carrying a small, teeny tiny suitcase, a police dog had sniffed at the suitcase and started barking. prompting the passenger to run into a men's room, open his suitcase, and flush a bag down the toilet before anyone could apprehend him. The dog's handler is prepared to testify that the dog has been trained not to bark unless it detects illegal drugs, and the dog started barking after sniffing the suitcase. The defense seeks to exclude the testimony by the dog handler. Exception. It's not an exception. I got it right. Admit the evidence because the offered evidence shows that the dog would not have barked unless illegal drugs had been present. If accidental death and suicide are the only two possible causes of death, the woman conclusively proves death occurred by violent means, and the insurance company produces no evidence to show that the boyfriend committed suicide. How should the trial judge rule? Okay. A woman, the named beneficiary of her boyfriend's life insurance. A woman, the named beneficiary of her boyfriend's life insurance policy sued the life insurance company for the proceeds of the policy. The insurance policy provides that double benefit should be paid in the case of the insured's accidental death, but no benefits are to be paid in the case of the insured's suicide. The woman has the burden of proving that her boyfriend did not commit suicide. State law provides for a presumption that death by violent means is not a suicide. The insurance company claims that the boyfriend committed suicide. If accidental death and suicide are the only two possible causes of death, the woman conclusively proves death occurred by violent means, and the insurance company produces no evidence to show that the boyfriend committed suicide. How should the trial court rule? Enter judgment as a matter of law for the woman because absent countervailing evidence, the presumption against suicide requires such a judgment. There's a jury. The jury decide the question of suicide. Let the jury decide the question of suicide, instructing it that the burden of persuasion I think you have to ask for a judgment a matter of law. I was going to put that answer, but I put the wrong one. The presumption is a rule that requires that a particular inference be drawn from an ascertained set of facts. It is a form of substitute proof of evidentiary shortcut, in that proof of the presumed fact is rendered unnecessary once evidence has been introduced of the basic fact that gives rise to the presumption. In this case, the basic fact is that the boyfriend died by violent means. The presumed fact is that the boyfriend did not commit suicide. Since the question specifies that the woman conclusively proved that the boyfriend died by violent means, the woman is entitled to the benefit of the presumption that the boyfriend did not commit suicide. Thus, the jury must find that the boyfriend did not commit suicide. unless there is contrary evidence produced by the insurance company, since the insurance company introduced no evidence to rebut the presumption against. Getting a phone call, but I think it's just a recording. Let's see. Hello? This is her. Well, how are you? 11188. Okay. Yes. Yes. No. Yes. Yes. No. Never. Yes. Yes. Okay, thank you so much. Thank you. That was my doctor because I have surgery next week. Might, I need to look at my paper. I'm supposed to go do like pre something. What's it called? Pre-op stuff. Was I supposed to do that today? It's only Wednesday. It was a Thursday. I think I do it next week. I'll need to look. I suck. I just got too much going on up here. Okay. So anyway, I'm not doing very good on this, but that's what it's for, right? That's what it's for. In which of the following situation is the cross-examiner forbidden from introducing an extrinsic evidence? Extrinsic. That's such a weird word. Evidence that that contradicts the answer of the witness. In a civil suit, the defendant's attorney asks a witness called in a civil suit. The defendant's attorney asked a witness called by the plaintiff whether the witness was involved in a long-standing feud with the defendant concerning an unrelated incident. The witness answered no. You cannot offer extrinsic evidence for that. In a suit arising out of an automobile incident, an eyewitness had testified that the plaintiff had a green light at the time of the accident. The defendant's attorney asked the eyewitness if prior to trial she told the investigating officer that the plaintiff's car went right through a red light. I think so. We're going to click that one. A defendant's attorney asked a witness if he falsely stated on his resume that he attended college. The witness said no. A defendant's attorney asked a witness if she was convicted of obtaining property by false pretenses 3 years ago. The witness answered no. A defendant's attorney asked a witness in a suit arising. I think it's B. It's C. A defendant's attorney asked a witness if he falsely stated on his resume that he. What? Why? A witness may be impeached on cross-examination with specific instances of conduct that are probative of truthfulness, but no extrinsic evidence may be admitted to prove that the occurrence of the conduct. Thus, the attorney is stuck with the witness's denial of the misconduct. I really want a Subway sandwich. I'm hungry. Answer A is incorrect. Evidence that a witness is biased or has an interest in the outcome of a suit tends to show that the witness has a motive to lie. What? A witness may always be impeached. I'm tired. I just want to know why my thing says Ashley Munson. Answer D is incorrect. Should the court rule that the testimony is admissible? A man is suing a bakery to recover for damage to the man's garage, which burned down from a fire that started in the bakery. The man alleged that the fire was started by one of the bakery's employees who was known to come in to the bakery. Where am I? Man alleged that the fire was started by one of the bakery's employees who was known to come into the bakery after an evening of drinking at a nearby bar to experiment with recipes. The bakery denied the allegations and claimed that the fire was a result of arson by a local gang member. At trial, the man called to the stand a court reporter who will testify that he recorded the testimony of the now deceased manager of the bakery at a preliminary hearing on a criminal charge of arson against the gang member, and the manager testified that the fire was the result of the employee's drunken experiments. At trial, the man called to the stand a court reporter who will testify that he recorded the testimony of the now deceased manager of the bakery I think it's a no, but the court you could be impeached with your own testimony. It is within an exception. The court should rule that the testimony is admissible as substantive non-hearsay evidence. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted and is inadmissible unless it falls within an exception to the hearsay rule. However, statements by an opposing party, commonly called admissions, are not hearsay under the federal rules. Certain statements by non-party declarants are attributable to the party as vicarious statements because of the relationship between the party and the declarant. For instance, the statement of a person authorized by a party to speak on its behalf can be admitted against the party as an opposing party statement. Furthermore, statements by an agent or employee concerning any matter within the scope of his agency or employment made during the existence of the agency or employment relationship are admissible against the principal. Here, the bakery's manager, an agent of the bakery, admitted during the preliminary hearing that the bakery's employee was at fault for the fire. This statement by the manager is admissible against the bakery as a vicarious statement of opposing party. Well, isn't that some shit? Gonna fail the bar. Is the son's testimony admissible? A defendant was charged with murder in connection with a carjacking incident during which the defendant allegedly shot a victim while attempting to steal the victim's car. The prosecutor called the victim's 4-year-old son whose face was horribly disfigured by a bullet fired by the defendant in the same incident, to testify that the defendant shot the victim. There were no other witnesses to the shooting. Is the son's testimony admissible? Yes. Yes. Yes, provided there is sufficient basis to believe that the son has personal knowledge and understand his obligation to testify truthfully. Is this question objectionable? A grantor transferred a deed to a grantee. The grantor's legal guardian brought suit against the grantee to set aside the deed on the ground that the grantor was incompetent at the time of the transfer. The guardian called the grantor's friend. The guardian called the grantor's friend to testify about a conversation he had with the grantor shortly before the deed was delivered. In that conversation, the grantor told the friend that he was guided by spiritual voices that told him what to do. The guardian's attorney asked the friend, the grantor was serious about listening to the voices, wasn't he? The grantor's legal guardian brought suit Yes, because it's leading. Can't ask leading questions on direct. So if you call a witness to the stand, you can't ask questions like, the sky is purple, isn't it? You say, what color was the sky? But, contrary on cross, if you're crossing someone, you can ask leading questions. You can say, the sky was green, isn't that correct? And it was raining while the sky was green, right? And then you crashed your car into the bushes, correct? And then they answer your questions. About which of these facts will the jurors most likely be allowed to testify? About which of these facts will the juror most likely be allowed to testify? So, right off the bat, jurors usually are not allowed to testify. So, let's see. A plaintiff sued a defendant for fraud. After a verdict for the plaintiff, the defendant talked with the juror about the trial. After a verdict for the plaintiff, the defendant talked with the juror about the trial. The juror informed the defendant that during the trial, 1, he had misunderstood the judge's instructions concerning the standard of proof in fraud cases. 2, he was feeling ill and needed to get home quickly. 3, he had relied on testimony that the judge had stricken and ordered the jury to disregard. And 4, he had learned from a court clerk that the defendant had been accused of fraud in several recent lawsuits. Hoping to receive a new trial, the defendant wants the juror to testify as to these facts in a post-verdict hearing. About which of these facts will the jurors most likely be allowed to testify? He had learned from a court clerk that the defendant had been accused of fraud in several recent lawsuits. Yep, that doesn't really matter because he learned it. He didn't necessarily use it. He was feeling ill and needed to get home quickly. He had misunderstood the judge's instructions. He had relied on testimony that the judge had stricken and ordered. I think that one. D is the correct answer. Let's see why. D is the correct freaking answer. Under the federal rules of evidence, a juror generally may not testify in post-verdict proceedings as to matters or statements occurring during the course of jury deliberations. However, a juror may testify as to whether why can't I say this word? Extraneous prejudicial information or any outside influence was improperly brought to bear on any juror. The fact that a juror received evidence about the defendant's involvement in similar lawsuits from an improper source is considered prejudicial information. Well, ain't that some shit? Thank you, Justin. I'm so sleepy. Go to work. And then I'm studying now. And then I have to go be a judge for a comedy thing in a little bit. And then I'm sleeping. I have to wake up early, too, for a doctor's appointment. Is the evidence admissible? A plaintiff brought an action against a defendant for property damages, alleging that the defendant's car nicked the side of the plaintiff's truck while the defendant was changing lanes on the expressway. At trial, the defendant sought to introduce evidence of her good driving record. No, you cannot use this because it is self-serving. No, you cannot use it because it is improper character evidence. That is self-serving. The physician's opinion is a beekeeper sued the manufacturer of a specifically designed helmet and face guard that was designed to protect the wearer from bee stings. The beekeeper alleged that he was wearing the helmet and face guard when he was stung on the left cheek by a bee that had entered through a small tear in the face guard, and that 1 hour later the beekeeper suffered a heart attack. The beekeeper's physician, having listened to the beekeeper testify to the foregoing facts at trial, is called by the beekeeper as an expert. Oh no, my computer's about to die. Hopefully my husband gets my message and brings me my charger. What question number am I on? I'm almost halfway done. Pause it until he comes back with my stuff, if he does come with my charger. I just want to take a nap. This part is broken. Another one somewhere. I do. I don't know if it works though. Let's see if this baby works. Oh, it works. Good job, me. Okay. Resume. The admissible confession was speakable treatment. The legal resolution. How should the court rule? In a medical malpractice action, a surgeon was called as an expert witness by the plaintiff and testified that the surgical procedure utilized by the defendant was so new and experimental as to constitute negligence under the accepted standard of practice in the relevant medical community. On cross-examination by the defendant's counsel, the surgeon was asked whether modern surgical procedures was a reliable authority in his area of specialty. The surgeon said that it was, and that the defense counsel then asked if the surgeon had relied upon the treatise in reaching the conclusion that the defendant was negligent. The surgeon stated that he did not. Defense counsel now proposes to read a passage from the treatise stating that the surgical procedure at issue is widely accepted by medical practitioners. See, for the plaintiff, so we're going to say no. For the defendant, but it should also caution the jury that the evidence may be considered only to impeach the surgeon. I don't think so. I think it can be for both. So for the defendant. Close my eyes. Ooh, I'm right. I was right. Good job, me. Pat my back. Over objection from the cabbie's attorney, how should the trial court rule on the admissibility of the neighbor's testimony? Over objection from the cabbie's attorney, how should the trial court rule on the admissibility of the neighbor's testimony? A driver brought suit against a cabbie following an automobile collision. A passenger who was riding in the cab testified that the driver ran a red light just prior to the collision, and that the cabbie was proceeding through the intersection on a green light. In cross-examination, the driver's attorney asked the passenger about the speed of the vehicles but not inquire about the traffic signals. The driver's attorney then indicated that he was finished with cross-examination, but requested that the judge ask the passenger to remain in the courtroom. In rebuttal, the driver's attorney called a neighbor of the driver who had helped the passenger out of the cab and brought him to his house after the accident. The neighbor is prepared to testify that the passenger said that the driver had the green light at the time of the incident. A driver brought suit against a cabbie following on a passenger who was riding the cab. The neighbor is prepared to testify that the passenger said that the driver had the green light at the time of the accident. Over objection from the cabbie's attorney, how should the trial court rule on the admissibility of the neighbor's testimony? We have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 14 questions, and I don't want to do them. I just want to go to sleep. Upon a motion by the grantees Upon a motion by the grantee's attorney to strike the question and answer how should the trial judge rule? A grantor gave a deed to a grantee. The grantor's legal guardian then brought suit against the grantee to set aside the ground. Trial, the guardian's attorney called the grantor's friend. The friend said the grantor told her that he was guided. How should the trial judge rule on the question? A defendant was on trial for murdering his wife. The defendant was called to testify on his own behalf concerning the death of his wife. On cross-examination, he was asked, "Isn't it true you were convicted of perjury?" The defendant had in fact been convicted of perjury 8 years ago. A defendant was on trial. For murdering his wife. The defendant was called to testify on his own behalf concerning the death. Isn't it true you're convicted of perjury? The defendant had in fact been convicted of perjury 8 years ago. How should the trial judge rule on the question? It is proper because once the accused testifies on his own behalf, it is proper. Once you come onto the stand to speak, your credibility goes into question. And so they can ask about things that have to do with lying, such as perjury. Will the court order the defendant to produce the report? The plaintiff was injured when she slipped at the defendant's restaurant. The defense attorney asked the manager on duty at the time of the incident to prepare a report of the accident. The report was given to the defense attorney prior to trial. During discovery, the plaintiff demanded that a copy of the report to be approved. The plaintiff was injured when she slipped at the defendant's restaurant. The defense attorney asked the manager on duty at the time of the incident to prepare a report of the accident. The defense attorney it's attorney-client privilege, so they don't have to give the report. 11 more questions, and I don't want to do them. I think I have 200 questions to do on the bar, and I'm only doing 30 right now. I'm so sleepy. Which of the following statements is correct? At the beginning of a trial, the plaintiff's attorney moved for all prospective witnesses to be excluded. This girl is on fire. This girl is on fire. Will the secretary's I'm hungry. Will the secretary's testimony be admitted? The defendant was at work when her husband called her and said, "The neighbor just tripped over those roots I told you to take out. He's badly hurt, and I'll bet he sues us for all we're worth." The defendant then told her secretary, "The neighbor just got hurt because I forgot to do my yard work." On returning home, however, the defendant discovered that the neighbor had actually tripped over roots from his own tree in his own yard. The neighbor disagreed and sued the defendant and her husband. At trial, the neighbor called the defendant's secretary to testify as to the defendant's statement to him. Will the secretary's testimony be admitted? No, because the defendant had no first-hand information when she made her statement to the secretary. No, because it is inadmissible lay opinion. Yes, because it is not hearsay. Yes, to impeach the defendant's expected testimony as the result of her own investigation. Amy? It is inadmissible lay opinion. Yes, because it is. Why the fuck isn't it hearsay? It's hearsay. The testimony is not hearsay because the defendant's statement constitutes an opposing party's statement. Is she an opposing party? I.e., a statement by a party, the defendant, being offered against her. An opposing party statement, commonly known as an admission, is not considered a hearsay. But is she a party, or was her husband a party? Which of the following statements is most accurate regarding judicial notice of the location of City Hall? A defendant is on trial for violating a statute forbidding possession of a concealed weapon within 100 yards of a government building. The prosecution presents evidence that the defendant was arrested on a street corner with a handgun in his pocket. The building housing the local City Hall occupies the entire block on the north and east sides of the two streets where the defendant was apprehended. The judge may take judicial notice of the fact this fact without resort to a map and should instruct the jury that it may but need not accept the fact as evidence of an element of the offense. Is the evidence admissible? A plaintiff suffered injuries when her car was struck by the defendant's car. The police arrived on the scene and required the defendant to take a breathalyzer test. The defendant was cited with driving while intoxicated, tried in traffic court, and duly convicted. He received the maximum sentence for driving while intoxicated, which is 90 days imprisonment in the county correctional facility. The plaintiff brought a civil action against the defendant seeking compensation for her personal injuries. At the trial of the plaintiff's suit, the plaintiff's attorney offers a properly authenticated photocopy of the court's judgment showing that the defendant was convicted while intoxicated. I was trying to see something. Oh no. Okay. Messing things up. The trial, the plaintiff's suit, the plaintiff's attorney offers a probably authentic photocopy of the court judgment showing that the defendant was convicted of driving while intoxicated. You can't bring, is that, no, because the crime, no. If, yes. That's a public record? No. What the fuck? No, because the crime was punishable by imprisonment of at most 90 days. Which of these convictions is admissible to impeach her credibility, even if the trial judge believes that the probative value of the evidence substantially outweighs this prejudicial effect and the adverse party has been notified? A criminal defendant took the stand on her own behalf. She had the following felony convictions on her record: a fraud conviction that is more than 15 years old, a conviction that was under appeal, a conviction for arson that is less than 10 years old, a juvenile conviction. A fraud, a juvenile conviction. Is it admissible? Yeah. Should the court permit the cab driver to review her notes while driving east? It's going to be yes, but we'll see. While driving east on a 2-lane highway, gotta do something real quick. I play a game called Matchington Mansion, and I just joined a new group, and they're like sticklers to like doing this one thing to send lives, and I forgot to do it all day, and I need to do it. Quest. While driving east on a 2-lane highway, a pickup truck collided with a westbound motorcycle. The accident was observed by a cab driver. Because the cab driver had a passenger, she did not stay at the scene of the accident but made some notes shortly thereafter. She made her statement to the police the next day, in which she stated that just before the accident, the pickup swerved into the westbound lane, hitting the motorcycle. At the trial of the motorcyclist, personal injury action against the truck driver, the cab driver was having difficulty remembering some of the facts. Yes, because it is. Yes, because it past recollection of court. No, because it had. Yes, because it is a present recollection or fresh. The court should be. Okay. How many more questions do I have? 1, 2, 5. 3 masked men robbed a convenience store, boo, during the course of which a clerk was killed, super boo. An investigation led the police to believe that the defendant was one of the robbers and they placed him under arrest. The defendant protested that he was innocent and volunteered to take a lie detector test. The test was conducted by a qualified polygraph expert. According to the expert's analysis of the test, the defendant lied about his participation in armed robbery. At the defendant's jury trial for armed robbery, the prosecution calls the expert to the stand to testify as to her analysis of the results of the polygraph. Polygraph test is considered to be unreliable. A plaintiff sued a defendant as a result of an automobile accident. After the plaintiff testified, the defendant called the plaintiff's neighbor to the stand. The neighbor testified that he had lived next to the plaintiff for the past 5 years. And hey, Aaron, and knows of the plaintiff's support. A plaintiff sued a defendant as a result of an automobile accident. After the plaintiff testified, the defendant called the plaintiff's neighbor to the stand. The The neighbor testified that he has lived next to the plaintiff for the past 5 years and knows of the plaintiff's poor reputation for truth and veracity. On cross-examination, the plaintiff's attorney wants to ask the neighbor if he is the chief claims officer for an insurance company that insures the defendant. Which of the following questions is most likely to be disallowed in response to an objection that is leading? What? Which of the following questions is most likely to be disallowed in response to an objection that is leading? The plaintiff filed a personal injury action against a restaurant. The plaintiff alleges that she suffered food poisoning. The restaurant defends by claiming that the special on the day in question was an exotic tea. Counsel for the restaurant called the former waitress. The former waitress who was plaintiff. Alright, I'm done because my mama just called me. So I'm going to call my mama back. Get ready for my night. Thanks for studying with me, people. I'm going to be trying to study a lot, so yeah.